Single.
Mention.
Not single.
Meetings for every side of a wall.
Appeal is a lordship. So this is a appeal from jail lordship and a statutory appeal may be admitted. Increase bill is for
Third,
increasing for
Mr.
B Haldar lordship.
B. Haldar, learned legal aid counsel for the accused appellant. NMS P. Bhuiyan, learned senior counsel and additional public prosecutor. It is assisted by MS R. Das, learned counsel for the respondent number 1, State of Assam. First, this criminal appeal under section 374(2) Code of Criminal Procedure 1973 is preferred against a judgment and order dated 13/3/2024 passed by the Court of Learned Additional Sessions Judge S2 within bracket FTC Tinsukia. In sections case number 150 within bracket T stroke 2022. Posted by the judgment and order dated 13/3/2024, the accused appellant has been convicted for the offenses under section 302, IPC and section 201, IPC. For the offense under section 302, IPC, the accused appellant has been sentenced to rigorous imprisonment for life and to pay a fine of ₹1,000, in default of payment of fine, to undergo rigorous imprisonment for 6 months. Post op. The accused appellant has been sentenced to undergo rigorous imprisonment for 2 years and to pay a fine of ₹1,000, in default of payment of fine, to undergo rigorous imprisonment for 6 months for the offense under section 201, IPC. Post op. It has been ordered that the sentences will run concurrently. Post op appeal is admitted for hearing. The case records of sessions case number 150T 2022 be called for, issue notice returnable in 4 weeks as MS Das assisting MS Bhuiyan has appeared and accepted notice on behalf of the respondent number 1, State of Assam. We issued a formal notice to the respondent number 1 is dispensed with. The accused appellant shall take steps for service of notice upon the respondent number 2 by registered post AD as well as by usual process within 3 working days from today.
There is an IA lordship for suspension of
We
sentence.
file an objection.
459.
Heard Mr. B. Haldar, learned counsel, learned legal counsel for the applicant, appellant, and MS P. Bhuiyan, learned so-and-so, assisted by so-and-so, for the opposite party, number 1, State of Assam. The instant application of the section 389 CRPC is preferred seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail. Post of the applicant as the appellant has preferred the connected appeal against the judgment and order dated so-and-so, so-and-so by the so-and-so judgment so-and-so, so-and-so. Notice be issued to the opposite parties. So the notice is made returnable in 4 weeks. As so-and-so appeared accepted, issuance of formal notice dispensed to it. Applicant appellant shall take steps for service of notice upon the respondent number, opposite party number 2 by registered procedure as well as by usual process. The application will be considered after receipt of the trial court records as already called for. Also, the learned public prosecutor. The objection to the application uh, shall be filed on behalf of the learned additional public prosecutor on or before the retardable date.
So chief, notice should go through officer in charge or
Registered post.
IPC offense.
Item number 2,
True Lordship, we have taken steps on R2. They have received it. I did not know. I did not.
I9. Two,
Item 2.
notice is not issued or what?
No, delay, there
Delay
are
condoned.
order, Lordship. Delay has been condoned.
Okay.
The subsequent order is there, Your Lordship, in the next page of the order sheet. Probably in advance it was done. I'm sorry, madam. In subsequent order, in the second page, I took time to obtain instruction as a service report. I don't know, like, it was not reflected in the order.
Hmm. No, in this appeal,
Delay has
it
been
is,
condoned.
no order has been passed till date. Delay
Yes,
has
ma'am.
been condoned
Condoned,
in the IA.
yes.
There, before allowing the IA, in the previous order, you took time to
For service
obtain
report.
instruction as
Yes.
regards service. report.
Ma'am.
Sorry, I'm making- I had to take on respect for it later. Dispose regulatory impact. Oh. Oh. Will you be going? Will you make it? This is legal aid counsel.
Her name is not her name is reflected. She's the legal aid counsel or person. I think she's the legal aid counsel. P Das Saksu,
He does.
Priyanki Das.
Uh-huh.
And nowadays she works with Mr. D. Saket.
Legal aid
I
counsel.
met her in the bar today itself.
কি করবো admit করি তো হুম।
Lordship, should it take steps again if your Lordship admits the matter?
Better you take steps. There is
Take
no
steps.
reflection in the order.
Yes.
Uh,
IA criminal 254/2024, which has already been condoned, my lord. That
Part, the direct legal aid counsel for the accused appellant is found absent today. On call be that as it may, full stop. This. The instant criminal appeal under section 374 to CRPC is prepared against a judgment and order dated 12/10/2023. Passed by the Learned Special Judge Jorhat in special case number 93/2020, comma, which arose out of Pulibor Police Station case number 639/2020 and ZR case number 3641/2020. Full stop. By the judgment and order dated so and so. The accused appellant has been convicted for the offences under section 4 within bracket 2 and section 8 of the Prevention of Children from Sexual Offences Act.
May I please, Your Lordship?
Hmm.
This is a
Continue work.
So Lordship, service report was called for by order dated 25/4/24.
Lordship,
Uh,
we have received a report from the concerned OC, Lordship, Johan.
Which is 302, Lordship, LCR has been received, paperwork has to prepare.
Okay. Third MS B Sharma, learned amicus. Paper ready?
No.
Learned amicus query for the accused appellant and MS S.H. Vora, learned additional public prosecutor for the respondent state. Post hoc. As the records, case records of sessions, case number 21, within bracket T stroke 2021 have been received, command the office to prepare the paperwork, place the appeal after 4 weeks.
Problem.
number 6.
Lordship, LCR has been called for and also received, so Lordship may fix the matter for hearing.
Paperbook is also ready, Lordship.
Report,
Paperbook ready, we'll get done.
Uh,
Lordship.
offense.
On the-
Same Nunmati,
Lordship, notice has been duly served upon respondent number 2, Lordship.
seven. Heard, Mr.
D government.
D.
On behalf of Mr. S. Bottom.
Your name is not appearing or
On behalf of Mr. S. Bottom, Lordship.
learning council appearing for Mr. Aswad,
Second.
learning council for the appellant. And MSSC for all learned additional public prosecutor.
My lord. My lord, on the last occasion, my lord, the
Yes, what about the surgery?
I have received report up to this.
See, we have a copy.
No, two
No.
copier.
Very taken care of.
hepatitis B positive has been detected, my lord. The experts can, my lord,
He is in GMCH.
my lord, that is correct, my lord. He is
Nothing
admitted. Admitted there.
is better than GMCH, at least in the state of Assam. So he's well taken care of.
Family member is, my lord, requesting that if under any stringent condition, my lord, if the bail is provided, then, my lord, in a private medical college, in a private hospital, my lord, we can undertake
That
this.
is not, when it is not reflected that we are not capable of
That is
doing,
not reflected,
Mr. Bhuya,
my lord, my lord.
when GMC is not saying that we are not capable of treating
My lord,
the patient.
I can understand. My lord, he is a.
We
person of around.
are not acceding to such submission.
My lord. Leave up to your lordships. My lord, then we can wait. My
Okay,
lord.
we'll decline. If you go on submission, we'll decline.
Lord, application may be keep pending, my lord, till the surgery is done or.
That can be,
Mine.
from time to time, we can take status
mine.
report. That
I'm not-
is a reasonable
My lord,
submission,
my lord.
but the other submission, we are not finding it very reasonable.
No, my lord, it is my submission. It is the, my lord, I am living up to your.
Court is also
My lord,
responding to the submission.
my lord. Then, my lord, the matter can be keep pending, my lord, till the surgery is done.
That is the best in the state. Heard Mr. A.R. Bunian, learned counsel for the applicant, and MS Mr. K.K. Das, learned additional public prosecutor for the opposite party number 1, state of Assam. Full stop. In deference to the order dated 31/5/2024, Mr. Das has placed a copy of a communication bearing number so-and-so dated 4/6/2024 from the office of the Superintendent, Guwahati Medical College and Hospital, GMCH, enclosing therewith a report, up-to-date status report regarding status report dated 4/6/2024 regarding surgery and the health condition of the applicants from the registrar, Department of Urology and Renal Transplantation. Sorry, registered Department of Urology, GMCH. Full stop. As per the said report, the health condition of the patient, within bracket, the applicant, is presently stable. Full stop. However, his surgery has been deferred as he is found to have hepatitis B positive. Full stop. It has been reported that an opinion from gastrology has been taken, and as per the advice of the gastrology, further investigations are to be undertaken. Have been undertaken. The reports in respect of which are pending at present. Full stop. In view of the above report, lays the case after 2 weeks on so-and-so date. Mr. Das, learned additional public prosecutor, is to obtain an up-to-date status report in respect of the applicant.
24/6.
Heard
Hello,
Mr. A.R. Bhuiyan, learned counsel for the appellant, and Mr. K.K. Das, learned additional public prosecutor for the respondent number 1, state of Assam. Report. Informant. Yes, what about the report from the informant?
Item 10. Item number 10.
Moriani police station. The learned legal aid counsel is found absent today on call, has sought for further 1 week time. 1 week time to obtain a report from the officer in charge. Orioni Police Station as the service of notice upon the respond opposite party number 2 that's informant stroke victim. It has I got this is the case after 1 week. As sought for by Mr. Das.
Tab 11.
Yeah, please, Lordship.
We are supposed to file objection, Lordship, kindly give us 1 week.
A. Mubarak, learned counsel for the applicant appellant, and MS S.H. Bora, learned additional public prosecutor for the respondent state. MS Bora, learned additional public prosecutor, has prayed for and is granted 1 week time to file an objection to the instant interrogatory application. First, list the case after 1 week
Kindly oblige, Lordship.
on a day of the expired hours. Oh, ঠিক আছে। Regular নাকি?
So,
হুম,
also may pass over the method for time being also.
কি করবো?
Yes.
Number 13.
May I please, your Lordship? Lordship 302, my lord. The deceased was the mother
Right.
of the informant and wife of the accused, my lord. The conviction was on 2 counts, my lord. First was that, my lord, at the stage of charge, hearing on charge, my lord, 228, my lord, the accused pleaded guilty, my lord. But the learned trial court, my lord, out of his discretion, my lord,
হুম,
felt better to go for the trial. So, my lord, the plea of guilty was, my lord, rejected, and my lord, the case was proceeded for this. And the second ground is that, my lord, as per the statement of the informant as well as the IO and the constable of the police station, my lord, the accused surrendered with the dao in the police station. Apart from that, no eyewitness is there, nothing is there. The weapon of the offences, my lord, as far as the FSL report is concerned, my lord, it was completely rusted, my lord. So, my lord, the wounds which are there as per the medical report, the 6 wounds, my lord, the disease received, my lord, should have been through a sharp weapon only, my lord, without being rusted, my lord. Because the medical report says, the FSL report says that the weapon of the offense was heavily rusted. And it was immediately sent, my lord.
let
But
us-
the FIR is page 4, my lord. Page 4 is the FIR. May I read, my lord? Humble submission is that around 10:30, 11 AM on this 4/10/15, my father, Sri Vishnu Urangia, resident of Abepur village, chased my mother, Mrinali Urangia, to the backyard of the house and dealt cut blow with a dao on several parts of her body and thereby causing severe injuries, and she died at the place of occurrence. I therefore pay to take necessary action upon investigation into matter. Now, my lord, the charge is at page 6, my lord. Charge is read over and explained to the accused. Accused has pleaded guilty to the act of killing his wife. He has stated that due to ill health, he could not go to work, because of which his wife and son used to mistreat him and did not provide him food. Losing his temper, one day he assaulted his wife with a dao and killed her. Nobody has come to meet him in jail. Considering the seriousness of the offense and severity of the punishment, I consider it fit not to exercise my discretion under 229 CRPC to convict the accused on a plea of guilt, but to proceed with the trial. So, my lord, if this is the position, then, my lord, the plea of guilty will be discarded, my lord, in the case, my lord. Thereafter, my lord, copies were furnished, my lord. Page 8 is the PW1, my lord, the son, Rajendra. My lord, it is not discarded. In the judgment, it is relied, my lord. But even otherwise, my lord, if the learned trial court did not use his discretion, once the accused pleaded guilty, my lord, then on the strength of the evidence available on record and the evidence adduced by the prosecution, my lord, the court has to proceed, my lord. 228, my lord. And
It
229
was
is the
reflected that he did not wish to exercise the discretion on 229.
229, my lord.
It
229.
was reflected in the order.
Not bound to accept it clear.
Yes, my lord.
There are several Supreme Court judgments.
Yes, ma'am.
where it is stated that in serious cases court should not usually
I know.
exercise the discretion. In favor of the, in accepting the. So trial has to be conducted.
Yes.
The plea was recorded.
Plea was recorded.
Clearly recorded.
And I had just marked my lord flag. दिखाओ मैंने कहा. The flag 8 is there. The specific plea is not there. The flag marked on orange. Mail.
Original law, otherwise suppose accused pleaded guilty
My lord.
at the time of framing charge
My lord.
or after the charge was explained to him.
Yes, my lord.
He pleaded guilty.
Yes, my lord.
but the trial court exercises the discretion not to accept the plea of guilty. Then what is the law that this can be taken as a circumstance while arriving at the final judgment?
No, my lord. Yesterday, my lord, some of the judgments I saw, my lord, but I did not read the copies, my lord. The law is on the stand that if at the stage of 229, if the learned trial court is not going to use his discretion, my lord, then the only point would be taken at the stage of argument and court to decide that part. Rather, my lord, if the prosecution fails to bring the offense against the accused, then, my lord, the plea of guilty will not come into a bar for convicting the accused person, my lord.
Where is the law?
I did not brought that, my lord, judgment, my lord.
Just now I have come across one judgment. It has to be while recording the plea of guilty, it should be in the form of like as the way the accused
My
pleaded
brother
guilty.
is saying that.
Yes. It should be recorded as such. Lordship, I'll take out the. Yes. Ma'am. Okay.
It one is-
It's an accommodation. Live law. There are same Baba here. We said it does. It doesn't give you the person.
Appropriately language. Informant is the son.
Yes, my lord.
Yes. Yes, sir.
Yes.
My lord, page 8. PW1, my lord. Rajendra Urangia. I know the accused person. He is my father. This is Mrinalini Urangia was my mother. She died around 6 months back. Prior to the incident, the accused used to always say that he would cut my mother, the deceased, and my younger brother, Moina Urangia, and my mother and my younger brother used to stay in the house with my father. My mother and also my younger brother reported to me that my father would kill them and then go to the jail on many occasions. On the day of occurrence, I was at Joypur. Then one of the villagers gave me a call at around 2 p.m. and told me that my mother, Moina Urangia, was cut by my father, the accused because of which she died. Immediately, I came to my residence, and on reaching my residence, I saw the dead body of my mother was lying in the corner of courtyard of our house. Then police came to the place of occurrence, and police was already there at my residence before my arrival. Police took the dead body to the police station and conducted inquest over the dead body. Exhibit 1 is the inquest report. Exhibit 11 is my signature in the inquest report. Then I also went to the police station along with the dead body of my mother, and in the police station, when I was present, the accused came to the police station with a blood-shimmered dao in his hand and confessed that he had cut my mother with the said dao, and police seized the said dao in my presence. Exhibit 2 is the scissor list. Exhibit 2-1 is my signature in the scissor list, and the dao was a mid dao. After that, I lodged a first information report. Exhibit 3 is the said first information report, which was written by a person in the police station as stated by me. Exhibit 3-1 is my signature in the first information report. Police also brought me to the court for recording my 164, my statement. Exhibit 4 is 164 statement, and Exhibit 4-1 and 4-2 are my signatures in the 164 statement. Police recorded my statement, and I stated before the police as well as in the court before the judicial magistrate, and I have deposed in the court today. Exhibit 1 is the said dao which the accused has produced before the police, which the police seized in my presence from the accused person. I have seen the said dao in the court today. Now, my lord, cross-examination. The azhar was not written by me. The azhar was written by second officer of the police station. I do not know his name. I do not know the contents of the first information report. I am not an eyewitness to the incident. I did not state before police that the villagers of my native village informed me that my father killed my mother. I also did not state before the IO that my father arrived at the police station with a blood-shimmered dao and confessed that he had cut my mother with the said dao. It is not a fact that my father did not confess before the police that he had cut my mother. I do not know the contents of Exhibit 2 scissor list. I put my signature on Exhibit 2 at Namrup PS. At the time when I put my signatures, the said paper was blank. I lost the azhar and also put my signatures on Exhibit 2 on being asked by the police. I do not know as to why I came to court prior to this day. I came to the court on the previous occasion on being asked by the police. I gave my statement voluntarily before the magistrate without being tutored by the police. I reached the court on previous occasion at 9 a.m. I met the judicial magistrate at 2 p.m. on the said day, I was given 10-15 minutes time for recording my statement. It is not a fact that what I have stated before the magistrate was tutored. It is not a fact that accused did not kill my mother. It is also not a fact that I have initiated this case based on misunderstanding and as heard from others. To the court, prior to the occurrence, the accused, deceased, and my elder brother used to reside in our house. I used to reside at Jaipur. Now, my lord, PW2, my lord, Mukund Gogoi. My lord, he informed the police at the first point of time, my lord. Thereafter, the GD entry was, my lord, noted down, my lord, on his information over phone, my lord. Mukund Gogoi, PW2. I know the accused person and deceased Mrinali Urangia, wife of the accused. She died about 7 to 8 months ago. I am the president of VDP of Abhaipur Gaon. On the date of occurrence, I came to know from the villagers that Vishnu Orangia murdered his wife in his house. Immediately, I went to the house of Vishnu Orangia and saw the dead body of the wife of accused was lying in the house compound of accused. Then I immediately informed the matter to Namrup police station. After a while, police arrived in the house of the accused person. Police done inquest on the dead body of the deceased person in my presence, along with several villagers. I saw several cut injuries over the dead body of the deceased person. Exhibit 1 is the inquest report and Exhibit 1-2 is my signature. Then dead body was taken to the police station. I also accompanied the dead body to the police station. When I was present in the police station, accused Vishnu Orangia came to PS with a dao in his hand and stated that he cut and murdered his wife. Police seized the dao from the accused person in my presence. Exhibit 2 is the seizure list. Exhibit 2-2 is my signature. Exhibit 1 is the dao. I have seen the seized dao today. Police seized the said dao. Rajendra Urang, son of the deceased, filed Ajar. Police recorded my statement. Police took the dead body from the PS for post-mortem examination. I have also come to court for recording my statement by magistrate. Exhibit 5 is the statement before magistrate. Exhibit 5-1 and 5-2 are my signatures. Now, my lord, cross. I have not seen the alleged incident. I do not have any personal knowledge in regards to the alleged incident. I do not remember if police took my statement. This is relevant, madam. I did not state before the police that accused Vishnu Orang came to the police station with a dao in his hand. I did not state before police that accused Vishnu Orang admitted his guilt before the police. I have not gone through the contents of Exhibit 2 at the time of putting my signature thereon. I do not know as to why police obtained my signature in Exhibit 2. I came to the court to record my statement under 164 CRPC on the information of the police. I have deposed before the magistrate as per my knowledge about the incident, which I have heard from others. I cannot firmly say that Exhibit 1, that is to the dao, is exactly the weapon used in the crime, as there is no identification mark on the seized dao. There are similar daos available. It is not a fact that what I have deposed today is all false, and I have given my evidence in the case as because I am the president of Gaon Panchayat. Now, my lord, PW3, my lord. Tonkeshwar Gogoi, my lord. Page 13, my lord. May I read, my lord?
None. Yes.
PW3, my lord, Tonkeshwar Gogoi. I know the accused person and deceased Mrinalali Urangia, who was the wife of the accused. The incident took place about 1 year ago. On the day of incident at about 11:30 a.m., I got information from Mukund Gogoi that Vishnu Urangia assaulted and murdered his wife in his house. Then I, along with Mukund Gogoi, went to the house of the accused person and Mukund Gogoi informed the matter to police. After a while, police arrived in the house of the accused person. I, along with the police person, went to see the dead body, which was lying in the house compound of the accused. Police done inquest on the dead body of the deceased person. Exhibit 1 is the inquest and Exhibit 1-3 is my signature. I saw cut injuries on the face and several parts of the body of the deceased. At that time, we have not seen Vishnu Urangia in his residence. Police took the dead body to Namrup PS. I also accompanied them to police station. Accused Vishnu Urangia went to the police station along with a dao in his hand when we were present in the police station. Police seized the dao from the accused person. Exhibit 2 is the scissor list and Exhibit 2-3 is my signature. Police recorded my statement. I also came to court for deposing my evidence before magistrate. Exhibit 6 is my statement under section 164 CRPC. Exhibit 6-1 and 6-2 are my signature. Exhibit 1 is the dao which was seized by police from the accused person. Now cross, my lord. I have not seen the incident. I did not state before the police that accused Vishnu Urangia came to police station with a dao in his hand. I also did not state before police that accused admitted his guilt before the police. I do not know the contents of Exhibit 2. There are similar daos available in the market. I cannot say exactly that the weapon in the alleged incident and the weapon shown to me today in the court are same. I do not have any personal knowledge about the alleged incident, and also I cannot say who is involved in the crime. It is not a fact that as we could not trace out the real culprit, we have implicated Vishnu Urangia in the case. It is not a fact that deposed falsely in the court. Now, my lord, this is the PW4 is the first person, my lord, who saw the dead body, my lord. This boy, my lord, PW4, Sanjeev Sonwal, alias Bhai. I do not know the accused person. The incident took place about 7 months ago. On the date of occurrence at about 12 noon, I was playing football. It should have been at Abhaipur playground near the house of Moina Urangia. When the game was over at about 12:30 in the noon, I went to the house of Moina Urangia, the other son of the my lord, the deceased my lord, to drink water. Then I went to the back of the house of Moina Urangia for urinal. Then I saw that a woman was lying on the back of their house and immediately told Moina Urangia about the matter. Then Moina Urangia came immediately and told that the woman was his own mother. I also saw that blood was oozing out from her hand. Then Moina Urangia informed the incident to the neighbor and also to the police. About half an hour, police came to the place of occurrence. Later on, police recorded my statement Later on, I came to know that deceased was murdered by her husband, that is to say, accused person. Cross, my lord. The football match started at 10 a.m. There were about 100 to 150 people who gathered to watch the football match. It is not a fact that I deposed before the police that when I went into the house of the deceased for a glass of water, I was accompanied by 3 other persons into the house of the deceased, namely Tankeshwar Sonwal, Prasanto Gogoi, and Bitupon. We went into the house at about 12:30 to 1 p.m. Maina, this is the other son, my lord. Maina went into the house just ahead of us. I do not know whether the door was locked from inside or outside. It should have been or, my lord. Maina did not came out of the house thereafter. I do not have any personal knowledge about the alleged incident. It is not a fact that I heard and came to know that the accused was involved in the incident. It is not a fact that I deposed falsely before the court. So, my lord, as per the prosecution case, my lord, this Sanjeev Sonwal was the first in point of time who have seen the dead body. PW 5, page 17, my lord. Pallavi Sonwal. I know the accused person and deceased Nrinali Urangia, who was the wife of the accused person. The incident took place about 7 to 8 months ago. On the day of occurrence at about 1 p.m., I was enjoying football game near my house along with several villagers. At that time, Moina Urangia, son of the accused person, went towards us and told us that her mother was cut, and he also told that she was no more. Then I informed Monju Gogoi and Tankeshwar Gogoi of our village about the incident over telephone. After half an hour, police arrived at the place of occurrence. I also went to the house of the accused and came to know that the dead body of Mrinali Urangia was lying in their house compound. Cross. I do not have any personal knowledge about the incident. I did not state before the police that I was watching the game of football near my house. The field, it should have been field, my lord. The field where football was being played was adjacent to the place of occurrence. There are 20 to 25 houses near the place of occurrence. Parmeswar Urangia and Jiban Sonwal are the 2 immediate adjacent household near the place of occurrence. Police did not take my statement. It is not a fact that no such incident took place and I have deposed falsely. PW 6, my lord, page 18 is the, my lord, doctor who conducted the postmortem, my lord. Dr. Nain Moni Pathak. On 5/10/15 at 12:45 p.m., I did postmortem examination over the dead body of Mrinali Urangia, female 50 years, in connection with Namru PS GD entry number 88 dated 4/10/15 and Namru PS case number 151/15 under section 302. The dead body was brought and identified by Tankeshwar Burwa and Rajendra Urangia, son of the deceased. On examination, I found following: female dead body of average build, dark brown complexion, wearing a mekhla chadar, yellow color blouse and the gamucha. Body and wearing garments are stained with dried blood, greenish discoloration of abdominal wall seen, body found cold both externally and internally, rigor mortis passing off and present partially over lower limbs. Injuries: chopped wound of size 15 into 3 cm, bone deep, horizontal over left side of face, extending from left ear lobule, cutting it up to left side of nose, cutting underlying tissues, including bones. So, my lord, it has to be very sharp weapon, my lord, because even the tissues and the bone has been cut, my lord. Chop wound of size 12 into 3 cm, spinal cord deep, over upper part of back of neck, horizontal, downwards, direction, cutting underlying tissues, vertebrae and spinal cord. My lord, this injury, my lord, as per the doctor, my lord, this was the vital injury, my lord, on the neck, which led to death of the disease, my lord. Chop wound of size 9 into 3, muscle deep over the left side of neck, 3 cm below injury number 2, horizontal, extending from angle of mandible up to 2 cm left to midline, cutting underlying skin, muscles and vessels. Injury number 4, chop wound of size 11 into 3 cm, muscle deep over left side of lower thoracic wall, cutting underlying tissues and exposing the lower 2 ribs laterally. Injury number 5, inside wound of size 18 into 1 cm, subcut nears deep over the left abdominal wall, anterolaterally 7 cm above umbilicus, with tailing of the wound towards medial aspect. Injury number 6, chop wound size of 7 into 2 cm, tendon deep over anterior aspect of right forearm, 7 cm above wrist, cutting skin and some of vessels, nerves and tendons. Membrane and brain healthy, pale, viscera are healthy, uterine cavity empty. Note. Now, my lord, note, my lord. There was a, my lord, the blood samples were sent to the FSL, my lord. That is why this note is there. Blood samples collected in the clot and NAF visuals and handed over to the escorting police, as requested by the investigation officer in his forwarding letter.
Which page?
My lord, in page number 19, my lord, NB is there, my lord. One note was there by the conducting doctor, my lord. And my lord would find page 74 and 75, my lord. Sorry, my lord, page 75 and 76. Page 75 is the, my lord, the blood sample and the DAO was sent to the FSL, my lord. Page 75. And 76 is the report, my lord, in the paper book, my lord. And 76 is the report, my lord. The parcel, one sealed cloth covered carbon box, consists of 2 exhibits enclosed with a cover, which was sealed with the impression of a seal corresponding with the seal impression forwarded. Description of article number 1. One wooden handle mid dao along with covers contains a stain of suspected blood marked as A, MR number 72/15, mid dao heavily rusted. Mid dao heavily rusted. The cover wrapped with plastic rope, blue and yellow colored, total length 45.5 cm. 2 numbers of airtight vial, EDTA vial contains blood sample marked as B. There is not found any cotton in the time of opening. TM number 110015. The result says that, my lord, both the blood, my lord, gave positive test for human blood and group of A, my lord.
Otherwise,
If the note of the doctor is taken out, then, my lord, it is presumed that it was the blood of the deceased only, my lord. Because the note,
it mentions, the
Yes.
sample mentions, come to page 76.
yes, my lord.
It mentions about the postmortem number.
Yes, ma'am.
1100 stroke
Yes, ma'am.
2015.
That's correct, my lord.
So we have seen the postmortem now,
Yes, ma'am.
examination report. It says, where is the postmortem examination report?
My
You
lord,
can pay 63.
page 63.
See, the PMR number
Yes, ma'am.
1100-2015.
Yes, ma'am.
So this could be a link
Link. my lord.
in the
Yes,
chain. Could be a link in the chain,
ma'am. Link in the chain.
but chain is to be complete.
Chain has to be. Now, my lord, opinion. Death was instantaneous following the neck injury sustained. All injuries were antemortem caused by sharp cutting weapon, my lord. Sharp cutting heavy weapon, my lord. Now, my lord, the weapon which, my lord, the went to the FSL, my lord, this was heavily rusted, my lord.
But it does not say that it is not sharp.
My lord,
It is rusted.
my lord, since the injury which lordship has seen, my lord, and my lord, the such rusted, my lord, thou cannot, my lord, in no circumstances, my lord, can inflict that sort of injuries, my lord. I'll come thereafter, my lord. I'll come, my lord. There are other evidences.
Who says it is rusted?
My lord, the
Yes,
FSL, my lord, page
FSL.
76. Page 76. On the day of,
Come to the report.
yes, my lord, 22nd of November, 2015, my lord,
And the offense?
410.
410, my lord.
Okay, after 1 month. Where it says rusted?
My lord, page 76, my lord.
Serial number 1.
Serial number 1, my
Third
lord.
line.
Third line, my lord.
Yes.
My lord, Exhibit 6 is the page 19, my lord, again. Exhibit 6 is the post-mortem report and Exhibit 6.1 is my signature and my opinion has been concurred by Dr. R.K. Gogoi, Professor and Head of Department of Forensic Medicine. Exhibit 6.2 is the signature of the Dr. R.K. Gogoi, which I know. Exhibit 1 is the inquest report and Exhibit 1.4, 1.5, 1.6 are my signatures in the inquest report. Exhibit 7 is the dead body challan and Exhibit 7.1 is my signature in the dead body challan. Cross. The alleged weapon was not shown to me. There is possibility of immediately screaming after sustaining the injury. So, my lord, would recall, my lord, one part, my lord, there was a football match and several villages were there, my lord, by the time. In my report, there is not any mention about the first sustained injury and the injuries thereafter, including the last. I cannot say if the injury number 2 and 3 were inflicted after the other 4 injuries. There is every possibility that victim might have tried to save her if the other injuries apart from 2 and 3 were sustained prior to these injuries, man. Because as per the doctor, man, 2 and 3 were the vital, man, injuries, and for that, man, the death was instantaneous, man, immediately.
That is instantaneous,
Yes, sir.
but other injuries are there.
Yes. I cannot say the time required by a person to inflict the other 4 injuries. Now, PW7, my lord, he is the constable of the Namrup police station, my lord. Page 21, my lord, PW7. I know the accused person. On 4/10/15, I was posted at Namrup PS as constable. While on duty at around 7 p.m., the accused person accompanied by a village defense party person of Udaipur village came to the police station in a bike, and the village defense party person told me that
Yes, Mr. MS Bhuya,
Lordship,
you show the Dow to everybody, but not to the doctor. Conspicuously.
Right.
PP choose not to show the Dow to the doctor,
doctor, who did the
and
autopsy.
you showed it to everybody else. One of the pertinent question could have been that whether these kind of injuries were possible by this kind of alleged weapon of assault.
Right.
I think he was the best person to say so.
Lordship,
Yes, it was possible or not possible.
Well,
But
that was
PP,
not done.
PP decided
Not
not,
us.
not to show the Dow to the doctor and to show everybody else. Noticeably.
But the Lordship, blood sample matched with the PM report.
No, why this is a case of circumstantial evidence.
Lordship,
So PP has a duty.
Lordship, heavy duty on the PP.
These are supposed to be links.
Right.
But he was not shown the
Weapon also,
weapon of offense.
Lordship.
Is there any training program held or not? Or,
Nowadays,
Huh?
it is held, nowadays, well,
okay.
village defense party person told me that the person who was with him had killed his wife and the dead body was lying in the police station. I saw that the accused person was carrying a dao in his hand. Then I got the accused inside the police station and produced him before the IO. Then the IO seized the dao which the accused was carrying. Police recorded my statement. I also put my signature in the seizure list. When police seized the dao, Exhibit 2 is the seizure list. Exhibit 2-4 is my signature in the seizure list. Exhibit 1 is the dao which the accused person carried with him when he surrendered himself in the police station. And I have seen the said dao today in the court. Now cross, my lord. Police did not record my statement. I was posted for sentry duty at the police station. I was busy in my duty. It is not a fact that I was busy in my duty. I did not see the accused person carrying a dao in his hand. It is not a fact that I did not produce the accused person before the IO. I have put my signature in Exhibit 2 on being asked by the police to do so. The other persons who were on duty at that time were LC Andhra, SI Tutia, and other 5 police personnel present in the police station. I do not remember the names of the other police personnel. It is not a fact that the dao which has been produced today before the court is not the same dao which was seized by the police. It is not a fact that I deposed falsely before the court. Now, my lord, PW 8, my lord. Now, he is the person alleges that he took him to the motorcycle to the police station where the accused surrendered, my lord. I know the accused person. He is my neighbor. I do not know the informant. I know the deceased Mrinali Orang, who was the wife of the accused. The alleged incident took place about 2 years back. On the day of occurrence at about 6:30 p.m., I was returning from Jaipur police station to my. While I was heading to Jaipur police station, I received a phone call from Namrup police that the accused has killed his wife. While I was returning home, I met the accused person along with a dao in his hand, and I asked him where he was going, to which he replied that he was going to Namrup police station and asked me to accompany him to Namrup police station. He also told me that he had killed his wife and so he wanted to go to the police station. Then I, along with the accused person, went to the police station. I have seen the dove which the accused was carrying to the police station in the court today under objection by defense. Police recorded my statement. Now cross. The distance between the Namrup police station and Jaipur police station is about 10 kilometers. I have not stated before the police that while I was proceeding towards Jaipur police station, I got a phone call from Namrup police station that the accused killed his wife. There are different roads leading to Namrup police station and Jaipur police station from Habjan Tea State. It is not a fact that I have stated before the police that while returning, I met the accused on the way and he asked me to take him to Namrup police station. It is not a fact that I did not meet the accused person carrying a dao while returning and he asked me to accompany him to Namrup police station. Police did not record my statement. But now interestingly, my lord, PW9 says that accused came along to the alone to the police station, my lord. This PW9.
1 minute. It's a normal. Oh. Wait.
Start PW9.
PW8.
8. PW9 page 25, my lord. He is the investigation officer, my lord.
Hmm.
SI Deepak Sutrodhar.
Yes. Yes.
On 4/10/2015, I was on duty as SI of police at Namrup Police Station. On that day, at about 12:27 p.m., the village defense party president Abhayapuri Gaon, Sri Mukut Gogoi, informed over telephone that one Sri Vishnu Urangia has cut and killed his wife. A journal diary entry was made by Namrup PS GD entry number 88, dated 4/10/15, and I was endorsed to take up the investigation. Immediately, I went to the place of occurrence along with my staff. On reaching the place of occurrence, Sri Rajendra Urangia, the son of the accused, shown the dead body of Mrinali Urangia in the vegetable garden, Pasoli Bari. An inquest was conducted over the dead body in presence of Mr. P.K. Das, Circle Officer, Namrup Revenue Circle. I prepared the sketch map of the place of occurrence. Exhibit 8 is the sketch map and Exhibit 8.1 is my signature. I recorded the statement of the witness in the place of occurrence. My lord, this is important
Why?
because others, 3 of them says that their statements were recorded in the police station, my lord. The dead body was sent to the police station. On the next day, the body was sent to the Assam Medical College and Hospital, Dibrugarh, for autopsy. On the same day, at around 6:30 p.m., one Sri Rajendra Urangia lodged an HR with Namrup Police Station regarding the said incident, and the same was registered at Namrup PS case number 151/15 under section 302, dated 4/10/15. And I was endorsed as I already taken up the investigation. I was endorsed by Jolat Thanga Borua, Inspector and Officer in charge of Namrup Police Station. Exhibit 3 is the first information report. Exhibit 3.2 is the signature of Jolat Thanga Borua, the officer in charge of Namrup Police Station, which I know. Exhibit 9 is the extract of the journal diary entry number 98, dated 4/11/15, certified to be true, which was regarding the receipt of the first information report. Exhibit 9.1 is the signature of SI Ganesh Shutia. On the same day, at around 6:45 p.m., the accused Vishnu Urangia appeared in the police station along with the dao, which was with a case. Well, it should be a cover, which he used for the assault. The said dao was seized in presence of the witness. Exhibit 2 is the scissor list and Exhibit 2.5 is my signature. Material Exhibit 1 is the said dao. I recorded the statement of these scissor witnesses and also the statement of the accused person. On the same day, I arrested the accused person in connection with this case. I forwarded 3 witnesses, Rajendra Urangia, Mukut Gogoi, and Tankeshwar Gogoi, to the court for recording their statements under section 164 CRPC by the magistrate. I forwarded the accused person to the court for judicial custody. I collected the blood sample of the deceased, Mrinal Urangia, and sent the same to forensic laboratory along with the dao for examination, which I have seized. Thereafter, I collected the FSL report and the postmortem report and also the 164 statement of the witnesses. Exhibit 10, Exhibit 11 are the FSL report from FSL Khailipara, Guwahati. On finding sufficient materials against the accused person, I filed the charge sheet under section 302 IPC. Exhibit 12 is the charge sheet. Exhibit 12.1 is my signature. Cross. I went to the place of occurrence on the same day of occurrence. I recorded the statement of the witnesses during the daytime on the basis of the journal diary entry, as I did not receive the HR till then. I recorded the journal diary entry on receipt of information from the village defense party president, Sri Mukut Gogoi, over phone. According to the sketch map, Exhibit 8, I have not pointed out the house of Parmeshwar Unangia and Jeevan Sonwal near the place of occurrence. It is not a fact that I have not shown the adjacent house of Parmeshwar Unangia and Jeevan Sonwal in the place of occurrence, as I have not examined the place of occurrence. According to my investigation, the dead body was first noticed by Sri Sanjeev Sonowal. And the body was found outside the house, inside the vegetable garden. It is not a fact that Sanjeev Sonowal did not see the dead body first and the body was not lying inside the vegetable garden, but the body was inside the house. I have not recorded the statement of Maina Hunt, but I have recorded this statement of Maina Urangia, the other son of the deceased, my lord. I have not recorded the statement of Tankeswar Sonowal, Prasanto Gogoi, and Bitupon, but I have recorded the statement of Tankeswar Gogoi. The accused Vishnu Orangia was alone when he entered into the police station, my lord. This is important. Because if this is taken, my lord, then PW 8 and 9 are discarded, my lord. It is not a fact that when Vishnu Orangia came to the police station to find out about his deceased wife, we arrested him. I have not seen the cover case of the Dow in the court today. It is not a fact that I did not seize any Dow. It is not a fact that I have taken signature of the witnesses on plain papers. I have not submitted any document given by doctor that the blood sample was the deceased victim blood sample along with the group of the blood. So, my lord, while he took the blood samples, my lord, he did not make any requisition of that from the doctor concerned, my lord. But however, my lord, the FSL doctors, my lord, he has in fact, my lord, stated that he took the blood and gave it to the IO as per the challan, my lord, as per the information from him, my lord. At the time of the incident, there was an ongoing football match in the football field, which was nearby the place of occurrence. I have noted down how many people gathered in the football field to see the football match. Sanjeev Sonowal stated before me that when he went to the deceased victim house, he was accompanied by other persons, but he did not name the said persons. It is not a fact that I have submitted the charge sheet against the accused person on suspicion. It is not a fact that I have perfunctorily conducted the investigation and erroneously submitted the charge sheet. My lord, he was re-examined, my lord, my lord, to exhibit the GD entry, my lord, at page 28, my lord. On 4/10/15, I was on duty as SI of police at Namrup Police Station. On that day, OC Jawlat Thanga Borwa, Namrup Police Station, entered Namrup PS GD entry number 88, dated 4/10/15, and I was endorsed to take up the investigation. Exhibit 13 is the extract copy of the GD. And exhibit 13(1) is the signature of Jawlat Thanga Borwa, which I know.
Where is that exhibit? 88. GD entry 88.
Yes,
Page,
Page 82.
Page 82, my lord.
page 82.
82.
Mukut Gogoi is PW2.
Yes, my lord. PW2. Now, my lord, PW10, my lord. The scientific
Yes.
officer, my lord.
Yes.
Page 20. On 9/11/15, I was working as scientific officer, Serology Division, DFS Kailipara, Guwahati. On that day, I received a parcel from my departmental in charge 9/11/15 in connection with Namrup Police Station case number 151/15 under section 302 IPC. When I opened the parcel, the following articles were found: burned wooden handle meat dao, along with cover contains stains of suspected blood, marked as A, MR number 7215, Caesar list number 1, my number 03603A, meat dao, heavily rusted.
Yes.
The cover wrapped with plastic rope, blue and yellow color, total length 45.5 cm approximately. Number 2, two numbers of airtight vial EDTA. File contains blood samples marked as B. They are not found any cotton at the time of opening the case. PM number 110015, Caesar list number 2, my number 0360B. Result of examination. Exhibits 03603A and 03603B gave positive test of human blood of group A. Exhibit 11 is the report and Exhibit 11.1 is my signature. Exhibit 10 is the forwarding report of the additional SP with the report. Exhibit 10.1 is the signature of the Director cum Chemical Examiner Sri Gajendra Nath Deka. Cross. Many human beings may be of blood group A. I have examined the sample forwarded to me, but I have not further examined beyond this. After investigation, the findings are recorded by the investigation officer on the worksheet. I am an analytical officer and I analyzed 2 blood samples and 1 meat dao, and not the sample belong to group A. But there was no investigation that both the blood belongs to the same person. I conducted the analysis as per requirement. Exhibit 11 was prepared by the typist according to my report, and I affixed my signature. I have not given any note in Exhibit 11 if my report has been compared with the worksheet maintained by the department. It is not a fact that I have conducted the investigation erroneously without observing rules. These are the witnesses examined by the prosecution.
What the trial court has observed as regards that pleading of guilty?
My lord, recorded, my lord. That is there, my lord.
No, where?
My lord.
Which paragraph?
Yes, my lord. Initial. My lord, para 3, my lord, second para, my lord, page 38. Page 38, my lord. Para 3, my lord. Para 4, sorry, my lord. Para 4. Line about 5 from the top, my lord. Para 4. From below, it will be 4 line above, my lord. The accused pleaded guilty, but to accord a fair trial to the accused without proceeding under section 229 of the Code of Criminal Procedure, the accused was afforded an opportunity for fair trial for the interest of justice.
Then any observation? Again, in the any other part of the judgment?
Yes, my lord.
Worship para 23.
Married, my lord. Married.
Yes, which part?
Para 23, my lord.
Para
Page
23.
45.
Para 23.
Page 45, my lord.
Yes.
It is clear from the exhibit 6 that Minali Urangia was head to death. The FIR is substantiated by the evidence of the informant. The evidence of the witnesses are corroborative. There is indeed clinking evidence that the accused is the person who killed his wife. The accused retracted his admission. He pleaded guilty when the charge was framed and particular offense was read over and explained to him. He justified his conduct by stating that he killed his wife because he was treated with cruelty by his wife and son, who never provided him with food. He pleaded that he was an ailing person and he was treated with cruelty. He killed his wife. However, the evidence is contrary. He also retracted his plea of guilt when his statement was recorded under section 313. Because in question number 1 of the 313, my lord, he stated that,
Which question?
my lord, first question, my lord.
First question itself.
Yes, first question, my lord, page 32, my lord. First. I am innocent. I do not know about my wife's death. I was taking care of the cattle, and when I heard, I immediately went to the police station along with the dog.
But that question was put, pleading of guilty, not.
No, my lord.
Okay.
Part was not put forward, 313, my lord.
Perhaps it is not a requirement.
Not a requirement, my lord. That's correct, my lord. Even the medical evidence of the doctor who conducted the postmortem, my lord, he said that even if these injuries are infected, my lord, there would be she would scream. But my lord, that is negated by a football match, my lord. In fact, my lord, that is negated by the football match, because if football match is going on, there would be more screaming than the TD. Third is that, my lord, the elder son, Moina Urangia, was not examined, my lord, who, as per Sanjeev Sonwal, was there at the place of occurrence. Neither his prosecution brought him as a prosecution witness in order to place on record the previous night quarrel or morning quarrel or any such, my lord, aspect which could show that there could have been some scuffle or some fight between the husband and wife prior to that. Nobody has seen the accused running away from there, my lord. That apart, my lord, all the witnesses have stayed, my lord. Nobody has seen. Police did not record their statements. That part is also there, my lord. Now the witnesses in the cross have also stated that we have not stated before the police that he came with a dao in the police station. However, my lord, 313, he himself admits So that part gets negated, my lord. Now, the vital part is that, my lord, the injuries which are there on the body of the deceased, my lord, cannot be in any situation through such an heavily rusted, my lord, dao, my lord. And your lordship has rightly pointed out, my lord, the dao, my lord, was never shown to the doctor who conducted the post-mortem examination, so that the defense could have taken at least put on a question that whether by this particular dao, this injuries can be infected. Because, my lord, injury part, one part, what the doctor says that with sharp weapon, my lord. This is there, my lord. I'll just read out only that part of the medical examination of doctor. My lord, PW 6, my lord. Opinion, my lord. At page
Yes.
19, first part,
Sharp
opinion.
cutting heavy weapon.
Sharp cutting heavy weapon. So, my lord, it is the admitted position that the FSL examiner have also stated that heavily rusted. And the report is also exhibited by the prosecution, my lord. From this, my lord, this injuries cannot, because bone deep are there, my lord. In fact, after cutting the skinnary part, my lord, the bones are also cut down. And, my lord, the other part remains is that there is not a certificate to the effect that this blood group belongs to the deceased, my lord. And, my lord, the case which was recovered with the dao, my lord, that case was not examined in order to bring on an aspect, my lord, that since the dao was inside the case, the blood could have been there in the case also, my lord. The case was also sent to the FSL, my lord, but no blood was found there, my lord, in the case.
You put any question to the forensic expert?
No, my lord.
Then
That was not put forward, my lord.
and the doctor who conducted autopsy, he categorically stated that he has collected the sample of blood.
Yes, my lord.
And the doctor and the forensic expert also mentioned in her report
Yes, my lord.
the PM number.
Yes, PM number, my lord. That is correct, my lord. But, my lord, the PW9 in his evidence says that he collected the blood.
He collected the blood. He is not the expert.
He's not. Because, my lord,
Doctor took out
he was
the
neither,
blood. That is the doctor said.
but he was
Blood
neither there in the,
was collected in clotted influenza vials and handed over to the escorting police as requested by the
Yes, ma'am.
investigating
Correct,
officer in his forwarding
Yes,
letter.
that
He
is there.
collected means
Yes,
he has not collected
He is
it
not collected.
from the body. He has collected it
My lord,
from the
the
doctor.
report of-
You have to be reasonable on that.
My lord, that is what, my lord, the FSL doctor, my lord, sorry, my lord, the postmortem autopsy doctor, my lord, he brought certain evidence showing that this blood was taken from the deceased, my lord, and was sent through the escorting police constable who took, and thereafter, my lord, immediately the said was sent through the additional SP to the FSL, my lord.
So far, tau and the body,
Yes, madam.
the blood collected
Yes,
from what? Collected from
The body of the victim, my lord,
body of the victim.
disease, my lord.
Belong to group A. That
Group
is
A.
what was the finding.
Was the finding. But blood was oozing out, my lord. That is already there, my lord. The blood was oozing out, my lord. They could have taken the blood because the body was taken in the police station also, my lord. They could have just placed the blood on the dao, my lord. Because such an rusted dao, my lord. And that apart, my lord,
What
none of
about
the-
his confession that he had killed?
well, as rightly pointed out by my lord, that it should be in a format, my lord.
No.
Yes, my lord, in a format, my lord, that judge judgment, my lord, if my lord allows me only one day on Monday, my lord, for 10 minutes, my lord, I'll place that part, my lord, only.
Two things.
Yes,
One is that plea of guilty, what will be the consequence?
Yes,
Suppose court has decided to use their discretion and not to accept the plea of guilty and decided to proceed the trial. Then after that, it would want to continue the trial. Not totally discarded. Not totally discarded,
Not totally discarded, my lord. That is correct, my lord.
considering the seriousness of the offense and the severity of the punishment, I consider it fit not to exercise my discretion under 229 to convict the accused on a plea of guilty, but to proceed the trial. So it remained like that.
Ma-
Now, some observations was made in the impugned judgment,
Yes, my lord.
but here also, I don't think there is heavy reliance.
Yes.
This fact is to be mentioned. That has been mentioned. So there, after appearing in the police station, he admitted his guilt by producing a dao. And not only that, there are three other witnesses. He said that, yes, he admitted his guilt.
He admitted his guilt.
So what
That
is the
part is-
consequence?
The consequence, my lord, that I have admitted, my lord, this is an extrajudicial confession on my part, my lord.
But there,
It's corroborated by the witnesses, my lord. But those witnesses, my lord, again in their cross-examination says that while we signed in the Caesar list, the paper was blank, or that was neither read over to them, first part, my lord. And the second part, they say that police did not record our statement. And the third part is that, my lord, I just place one more aspect, my lord. I have not stated before the police that so and so deposed that he has killed his wife, my lord. Those three aspects also they have contradicted in their cross, my lord. All the
Hello.
three.
what are the witnesses
My lord, first is
saying in 164?
164, my lord. My lord would kindly come to page 51, my lord. Page 57, my lord. Rajendra Urangia, first one, my lord.
Is
57. 57, my lord. Of Rajendra Urangia.
fifty-seven.
Yes, ma'am.
Whatever he has stated.
At 10 a.m. on
There
last
is a
Sunday.
plea of guilty. Whatever he has, the accuser stated before the magistrate.
No, 57.
Page 57, 164 statement, this Rajendra said that whatever he has stated, 164, that tallies with the contention of the accused person, whatever he has stated while plead guilty before the magistrate.
My lord, he says that Moina. My lord, 164 would kindly see, my lord.
Just a minute.
It was a statement made before police.
Yes,
So it is hit by section 25.
no, not before the police. Before this witness, my lord, 164, 164
He was
statement.
present at the police station.
That is there, Michael, while at that time police was there or not. Whether police was there or not, my lord.
No, what is
Not
this
sure.
statement? There is nothing in 57, page 57.
Yes, my lord.
164.
Moina Urangia informed me over phone that my father had
His
killed my.
evidence is hearsay.
Yes, sir.
He has deposed,
Yes.
he has,
Oh, yes, Moina Orangia has said, yes.
in 164 statement,
Yes.
PW1
yes.
has stated on the basis of hearsay.
Yes, sir, my lord. All three, my lord.
Moina. Now, where is Moina?
Moina
There is
not
no
there,
Moina.
No, Moina. Page 59, Mukut Gogoi, my lord.
I was informed. He saw the dead body.
No.
Mukut Gogoi saw the dead body,
Yes, my lord.
but so far the incident is concerned, how she died.
No, page
Yes, madam.
58, my lord, page 58.
Ah.
My father consumes alcohol, he does not work and asks money from us.
Hmm.
Earlier, after consuming alcohol, our father used to chase after us with an.
But he is residing in
Like us.
Joypur, my lord. He is not the son who is residing with the father, my lord. PW1 is residing separately, my lord. At a
But
separate
in,
place.
in the FIR he said, and in the 164 it said, it is not substantive piece of evidence.
Evidence.
But what did he say before the court?
It
What he
is a
said?
corroborative piece of evidence, 164, my lord. It was just corroborate. Lordship, may kindly see page 59 and 60.
We'll hear
Yes,
you, we'll hear you.
Lordship,
We'll put how you link the chain.
my lord.
We'll put anything more.
My lord, Mukul Gogoi and my lord, this case of 161 are not that convincing, my lord. They are also hearsay, my lord. But my lord, Mukul Gogoi says that at page 60, my lord, when he saw us, he said that I had hacked her. At page 60, my lord, this Mukul Gogoi says that in the police station, my lord, when he saw us, he has said that I had hacked her.
He speaks which belongs to Allah.
Other and eats them. He consumes alcohol. And my lord, the Tonkeswar.
It is, they are saying that yes, he is a person who creates disturbances in the
Yes.
locality.
Yes.
That might add weight, but to other evidence.
But in the cross part of all the, my lord, PWs, my lord, they have stated that they did not state before the police.
Hmm.
They have filed a police station with a blood simmer down and confessed that he had cut my mother with the same down.
Yes, firstly, on the point of plea of guilty, what is the consequence? What is the consequence?
My lord.
229,
My lord,
he pleaded guilty,
my lord,
but court decided to use the discretion and to proceed the
my
trial.
lord.
Now, whether it will be a circumstance in the chain of circumstances,
That I have to see, my
Huh?
lord, respect or.
First question.
Yes, my lord.
second, it has emerged from the evidence on record
My lord.
that inside the police station, he admitted his guilt.
Whether it will be barred, hid by section 25 of the evidence side. Yes.
In presence of police officers.
Whether your lordship will infer that, my lord.
No, in fact, not it. Tell me the settled law.
My lord, yes. In-
Tell me the settled law.
Yes, my lord.
No, definitely in police station, police will invariably remain present.
Say
But
they
depend
say
upon the
as
access to
soon
the lordship.
as soon as suppose a foreign embassy, people used to take shelter when his own country
My lord,
chases him.
lordship,
What is that? WikiLeaks or what?
my lord,
He has been there inside the foreign embassy for last 5-6 years.
my lord.
As soon as they enter, it is a territory of that country,
Country,
embassy. There, as soon as he enters the police station,
my lord.
he comes within the
Ambit of.
ambit of umbrella of police. Now, what will be the consequence of section
Lordship, I will-
26?
Lordship,
25-26.
my lord.
Secondly, thirdly, blood sample of the disease,
Deceased.
I don't know, both belongs to sorry, blood group of the body belongs to A, group A. Similarly, blood stains found in the Dow
Thou,
also
group A,
group A.
my lord.
But still, the scientific officer says that I have not examined whether this blood group belongs to the same person, right? Then, fourthly,
Hmm.
accused was not favorably disposed towards his wife and his sons,
Right.
right?
My lord.
Whether that will be a circumstance. Moina was not examined. He was the person
Yes,
who is to reside with his mother and father,
my lord,
and he was very much present in the vicinity.
my lord.
Then neighbors were not examined. Two at least
My lord.
were very much near whose residence.
Yes, Jivan Sonwal and my lord.
There is nothing on the aspect of last seen together.
Yes.
So possibility of involvement of others cannot be ruled out.
Last seen to, yes, ma'am.
Ah,
That's there.
since it is a circumstantial evidence, so it has some bearing. 313,
No,
he
sir.
remains silent.
My lord.
He has a right to remain silent. It is for the prosecution to prove. Then about Mr. Tiwari's submission that doctor was not shown
The material exhibit.
material exhibit. It would have been the best possible situation that yes, whether with this kind of allegedly rusted towel can be used as a weapon of assault to cause such injuries which were found in the deceased, on the body of the deceased.
My lord.
That is also a situation. You have shown the material exhibit everywhere, but
Except the doctor,
not to the doctor,
lordship,
right?
my lord.
These are at least few. He has provided an explanation in 313 to an extent how the Tao was produced before the court. And he also provided explanation, accepted or not acceptable or not acceptable is a different thing.
My lord.
But he said that Tao, I was taking care of the cattle. Right. And 164 statements, all are hearsay.
Apart from Moina.
And another part that
Extrajudicial confession.
he said that
The police
he
station.
said that Katilu or something like that.
Cutting pigs and my lord.
Huh.
Thereafter
That
consuming them, my
was
lord.
inside the police station. And one more thing
My lord.
which has become suspicious. This man.
Well, Samuel Beg, my lord. He says that he brought him. to the
Somehow
police station.
how he was coming to PW7.
Well, he was coming from.
How
somewhere
he
else.
was informed by police, well, he was riding a
Samuel
bike
Begum.
and leaves. What is the relation of PW7 with police?
My lord, that he has stated, my lord.
No, he
Because
was a
he's a village
constable.
party, my lord, defense party. He belongs from a
No,
village
PW8,
defense party.
PW8.
8, my lord.
He's a tea garden employee only. How,
He's my neighbor.
why he was informed by Jaipur police station when he was riding a bike? Namru police station.
Well, that is explained by PW7, my lord. That a village defense party person of Udaipur came to the police station in a bike with the village defense party person. Page
No,
21, my lord.
No, please see his evidence, PW8.
Yes, PW8, my lord, I've seen.
On the day of occurrence at about 6:30 PM, I was
Was returning
returning
from
from Jaipur police station to my something. While I was heading to Jaipur police station, I received a phone call from Namru police station that the accused has killed his wife. Who is he? Tea garden employee, occupation.
He was a neighbor.
Huh?
He's a-
Why he is called?
That lordship.
Then what he said? While I was returning home, I met the accused person along with a dao in his hand.
Yes.
And I
That's so
asked
weird.
him where he was going, to which he replied that he was going to Namru police station. And I asked, and asked me to accompany him to Namru police station. This story, he was riding bike to Jaipur police station. He was informed by Namru police station that accused has killed his wife. Why? Then he took the accused as a
Accused.
pillion rider with the dao in his hands and took him to the police station.
Lordship.
Bit difficult to.
And my lord, IO denied that IO said he came alone. IO in his cross.
No, that Kolisovo says that one person also came.
The police, well, the
Police
constables, he says
One
that
minute,
the person,
said he,
but he says that the person who brought the accused was a village defense party person.
Of Udaipur village.
Yes, my lord.
So,
Line number 3, my lord. Page 21.
page
21, my lord. PW 7, line number 3, my lord. While on duty at around 7 p.m., the accused person accompanied by a village defense party person of
name is
Udaipur
not
village.
disclosed.
Name is
Name
not.
is not disclosed, but
PW
Samuel Beck is not from Udaipur, man.
Huh?
PW8 is not from Udaipur.
PW8 is not from Udaipur.
Udaipur.
Yes, I resided Habjangaon Police Station, Namrup.
Namru.
Afghan now. Who is the otherwise occupation is tea garden employee.
Yes.
Yes.
He is not saying that he is from village defense party.
Hmm.
Then PW7 says that some village defense party.
Party.
Why you have brought PW7? That is also not. Why you have called him when he was going to Jaipur
Why? No connection.
and all of a sudden he met the accused with a dao in his hand. Then he asked him, okay, ride my bike, I'm taking to you. Namrup. He explained why, no? The video of PDP party. So these are few circumstances.
I'll try to
And the
satisfy them
authority,
without.
if suppose confession goes,
No, sure.
what else remains? What is the link? You want to say? What are the links?
Lordship, I think that he appeared before the PO, PS along with the minor.
GD entries are not exhibited.
GD entry, exhibit corner, page 82.
We have
Exhibit
seen-
13, my lord.
Hmm?
Exhibit 13.
Show us,
It was exhibited by IO or not?
show us from the paperwork.
Lordship,
We have seen in the records, but we have not seen in the paperwork.
lordship. If your lordship is saying that it's correct, my lord.
No, please tell us. That seizure of DAO, necessary GD entries.
Lordship,
Page 28.
exhibit is the first information report, 3 signature, page 25. The officer in charge knows, exhibit 9 is the extra copy of the GD.
74, page 74. There are two GD entries.
Oh,
Let us look at those. Page 74 first.
page 74. Yes, my lord.
That is
Exhibit
that
9.
that informant appearing in the police station, informing that his father chased his mother and dealt the blow on several dealt blows on several parts of the body.
My lord,
Right?
my lord.
That was GD entry
Exhibit 9.
98.
GD 98.
Then come to 82.
Exhibit 13,
Page.
page 82.
That is PDP president informing telephonically at the police station.
My lord.
First. Second entry, after receiving first GD entry, the OC proceeded to the village. These are all,
My lord.
but IO forwarded and SP forwarded all the GD entries to be exhibited, but prosecution decided not to
Not
exhibit.
to exhibit. No, no, no. Only exhibit 9 was exhibited. Exhibit 9 is the so and so.
It was all there
Lordship.
by forwarding letter. OC forwarded everything. GD entry 88, GD entry 89, GD entry 94, GD entry 98, GD entry 100.
My lord.
100 was the entry of the accused
My lord.
at the police station and surrendering himself with the dao.
Now,
But PP chosen not to exhibit. So these are, go through the records. Find out, can you retrieve the situation
Lordship,
on the basis of law only?
my lord.
And plea of guilty, that you have to, once the
Right.
accused pleaded guilty at the stage of 229, the court has decided to use, not to use the discretion
Suspicion.
to convict him at that stage and decided to proceed with the
Right.
trial.
Lordship,
Now, whether in the impugned judgment, the trial court has relied it or not,
my lord,
right?
my lord,
Find out.
Right.
I am asking you because there will be consequences.
my lord.
Consequence after pleading guilty.
Yes, I'll definitely. I've noted down.
Monday? Had Mr. Tiwari. Huh? Into it.
Wednesday was happening.
Wednesday fixes another.
নানটু কি সব বলে নানটু কি তারিখ 10 তারিখ
Lordship, can it be on Wednesday?
ওকে ওয়েডনেসডে for the amicus curiae for the appellant, MS on the request of MS Vivian, Senior Counsel and Additional Public Prosecutor. The appeal will be listed on Wednesday.
12/6,
For your
hard in part,
commission.
man. Hard in part.
It will be listed, we'll take up after
No, sir.
normal matters. I don't think others will be taken up.
Lordship, I'm extremely sorry, Lordship, I was not there when the matter was
Okay.
called. Can it be taken about 20th, Lordship? If it is convenient to your Lordship?
Okay, on the request of Mr. Ippolito and Micah Skibby for the appellant,
At your number 12. It's
can list on 20.
obliged.
May it please the Lordship. Lord, let me confess at the beginning. This is indeed a petition where the petitioner asks for little compassion to facilitate him to get the post. What happened, my lord, here? One post of grade 4 peon was advertised. Selection was made. 3 persons were selected. One was in the main list, they say, who is to be first offered the job, and 2 allegedly in the waiting list. I am second in the waiting list. The first one, in the main list they call it, he could not be ultimately offered appointment because there was some anomalies in his testimonials. So that goes, list goes. So these 2 persons remain waiting list. Offer was made to the first one. He joined, but unfortunately within 4 months, he expired. Post fell vacant. So I made a representation, since nothing was done, that I should be accommodated against that post. I am the only person now remaining in the select list. The authority respondent has not considered it. That's how I am before your watch.
Heard Mr. K.K. Mohanto, Clarence Senior Counsel, assisted by MS N. Begum, Learned Counsel for the petitioner, and Mr. Z. Bushra, Lion Standing Counsel, for the respondent. Lion Standing Counsel ZHC for the respondent. Post of a process of recruitment by an advertisement dated 29/03/2022. A process of recruitment was initiated to fill up a vacancy in the post of peon in the establishment of the respondent. Full stop. Responding to the said advertisement, the petitioner submitted his candidature. Full stop. Call letters were issued to the eligible candidates to appear before a selection board to appear in the interview struck Bhaira Bose before a selection board on 13/3/2023. Post of after completion the process, a selection list was published on 31/3/2023. Post of one, Ranjit Thapa was selected for appointment in a vacant post of peon. Post of the petitioner has averred that the said selected candidate could not be offered appointment due to certain anomalies in his testimonials. Post of while publishing the select list on 31/3/2023, a waiting list containing the names of 2 candidates was also published, wherein the petitioner's name figured at serial number 2 in the said waiting list. Post of. And it is the case of the petitioner that the respondent, as the appointing authority, had issued appointment letter in favor of the candidate at serial number 1 in the said waiting list. Post of on receipt of the appointment letter, the said candidate join in the post of peon in the establishment of the respondent. Post of what happened to him?
He expired, my lord.
In the month of November 23, according to his representation at page 20, annexure 4.
So vacancy
Hmm.
rules.
But in the month of নামটো দি দিব নামটো হ'ল
Pradip Bhakat.
Pradip Bhakat, huh?
Yes.
But in the month of November 2023, the said Pradip Bhakat expired. So as a result, vacancy has arisen in the post of peon for which the recruitment process was initiated by the advertisement dated 29/3/2022. Post office. According to the petitioner, since there is a vacancy in the post of said post, no, sorry, since the vacancy has arisen in the post of peon for which the recruitment process was initiated on 29/3/2023, and the waiting list, selection list, including the waiting list, is still in force.
Yeah, it was holding field.
Still in force, the petitioner submitted a representation before the respondent on 2/2/2024, seeking his appointment in the said vacant post of peon as the representation as the respondent has not paid any heed to the representation, the petitioner has approached this court by the instant writ petition, seeking interrogation. The direction to consider his appointment in the said vacant post of peon in the establishment of the respondent post of. Issue notice returnable in 4 weeks as Mr. Boishaw, learned standing counsel, he has appeared and accepted notice on behalf of the sole respondent, issuance of formal notice is dispensed with. However, MS Begum, learned counsel for the petitioner, shall furnish an extra copy of the writ petition along with an extra to Mr. Boishaw within 3 working days from today. The respondent shall make endeavor to file its response on or before a returnable date.
I have an interim prayer, my lord, so that the authorities will not go for any other process to fill up their post. That request is there. Let them respond with a notice.
Issue notice on the interim period. The prayer for interim review to be considered on the.
My lord, registry will
Returnable.
be directed to show my name.
Okay. The office to, the registry to reflect the name of Mr. G. Boishaw and standing counsel GSC in the respondent side in the cause list.
Problem.
Just 2 and 3 for getting.
I have honestly, some issue regarding IA.
IA, the amended post title was filed and the consultative petition also has been filed.
That cost title is done.
Well,
Heard Dr. A. Saraf. Learned senior counsel assisted by Mr. P.K. Bora, learned counsel for the applicant writ petitioner. Mr. A. Kolita. Learned standing counsel, Industries and Commerce Department for the opposite party number 1. Opposite party, that's respond number 1. And Mr. B. Gugoi. Oh, Mr. B. Gugoi. Oh, you are 2 also?
One
You are,
and
huh?
two.
Only one.
Yeah,
Mr. B. Gugoi, learned standing counsel, Finance and Taxation Department. For the opposite party, that's respond number 2 and 3, and Mr. S. Das. Okay, and Mr. S. Das, learned standing counsel, AIDC. For the opposite party, that's respond number 2 and 3. 3 and 4. Full stop. The instant interlocutory application is filed on behalf of the applicant writ petition. Seeking amendment to the seeking certain amendments in the accompanying writ petition, WPC number 2845/2017. Full stop. The applicant as a writ petitioner has prepared a connected writ petition, WPC number 2845/2017. But it has been averred that while preferring the writ petition, assailing a letter dated 16/3/2017 issued by the respondent AIDC Limited, comma, it has the applicant writ petitioner has inadvertently under due to an inadvertence, comma, had not assailed a letter dated 29/6/2016 issued by the Commissioner of Taxes, Assam, and a letter dated 14/2/2017 issued by the Industries and Commerce Department. Post of it is stated that both the letters, that is, the letter dated 29/6/2016 and the letter dated 14/2/2017 were part of the writ petition as annexers. Full stop. Stating that the same is a bona fide mistake, and realizing that the said two letters, that is, letters dated so and so and letter dated so and so, are required to be assailed the instant interlocutory application has been preferred, seeking amendment to the accompanying writ petition. Full stop. The applicant writ petition has reproduced has sought amendment of has sought by the instant interlocutor application, comma, the applicant writ petition has sought addition of 2 paragraphs, comma, paragraph number 20, capital A, and paragraph number 20, capital B, in the accompanying writ petition. Full stop. In addition, comma, the applicant writ petitioner has sought amendment in the prayer portion. Full stop. Of the accompanying writ petition. Yes. We admit. Allow?
Yes.
As the learned counsel for preparing for the opposite parties, as respondents. Learned counsel for the opposite parties, the respondents have not objected to such amendments in the accompanying writ petition. Full stop. Yeah. Considering that the two letters, that is letter dated so and so and the letter dated so and so, are already part of the accompanying writ petition, and there is no objection from the side of the opposite parties respondents, comma, the instant interlocutory application seeking amendments. As mentioned in paragraph 4. Of the instant interlocutory application, comma, is allowed. You have filed already?
My lord.
Huh? The amended writ petition. File along with the amending petition. ISC number 1587/2024 is taken on record. Yes. Anything you have to respond
On this number,
on this? No.
but I mean, in the IAM.
No, IA is allowed.
Is allowed, yes.
Now we are taking the amended writ
No,
petition.
we don't have anything. Only the prayer person and they have amended, we don't have any issues on this.
So we can record,
Yes.
or shall we proceed?
We can proceed because the arguments were already advanced.
No, so far, what that? In the second.
Second petition also, the arguments were
Ah,
advanced.
This we have recorded the facts. We have recorded the facts.
The arguments are the same, whatever in the first.
Then
petition.
affidavits, sorry, affidavits that we have filed, that will adopt that only.
No, about the hearing argument. He has said he has advanced the argument in both the writ petitions.
Right.
Right. So, in response,
Yes, we'll have to start.
That is what.
Yes, Lordship, okay, yes.
Well, the reference was only that, my lord, in this case, a reply was there by the government. But as I submitted last date, my lord, the reply only reproduces the Commissioner's taxes view. There is no opinion. So that cannot be taken to be the clarification by the industry part.
So, in your submission, you have reached up to page 191.
My lord.
Now the other two documents will be also
My lord,
part of your submission. 191,
my lord,
because my note is up to
my
191.
lord, absolutely. Only with that submission, my lord, that because the submission was advanced that the government's letter is to be treated as a opinion. So that I placed before lordship, my lord, that the government's letter only reproduces.
But otherwise, pages are same
Pages are same, my lord. Pages are same.
or any change?
No.
Because I'll be
No, my lord.
facing difficulty if the pages are changed.
191 sounds, I go to.
It will be a
No, my lord,
difficult exercise for
I
me.
told him that it will, to 191.
Or you give me comparative table, that will be very
No,
difficult.
no, it's same, my lord. Same,
191,
same, my lord. Same. We
okay.
adjusted the petition that so that.
Ah.
numbers, my lord.
Where are the other two then?
My lord.
Where are the other two? Because I have not.
That you
noted
will also
the-
find one letter is at page 189,
189, okay. And
190 is the Commissioner of Taxes and 191, 189 is the Industry Department. In fact, it should have been reversed first. The Commissioner of Taxes should have been there.
okay,
So only submission which was there, my lord, in this part, that this Industry Department letter, it only reproduces the letter of the Commissioner of Taxes, so it cannot be said to be that it has been approval or something in the 12.4, that is not there.
yes. Anything more?
No, my lord.
So Lordship, the basic arguments that my learned senior has made.
In which
In two
you will
topics.
address this one or that one?
Lordship,
There are two repeats.
2797 can be taken up first, then Lordship will go to the other
2797.
one, the amended one.
2797. 2014.
It's almost same, Lordship. Only thing is that a couple of that decision and all these things have been brought in the second one.
2797 might take completely. Take on it will be.
You already have.
Yes.
In fact, arguments were already advanced.
No, actually,
No, we have.
I think you
he has
also,
not.
no, he has also noted it, but it was.
No, no, it is blank.
Oh.
I have only accepted, no.
I argued the earlier time, Lordship. Earlier Lordship was heard once. That time we are good.
Then there was a gap.
Then there was a gap. That's why Lordship,
Big
that my, yes, we can. My senior has argued that.
No, you cannot.
Then. So I'll just, I don't have.
No, I am not, yes, Gogoi's submission to an extent was.
That time, other side was not present.
Oh, Mr. Kolita was. Okay, okay. Just say you are there. Yes, there is something. Okay. There is something. From your side also.
Right.
Just refresh.
I'll rephrase it. Lordship, what has happened is that in 2003, there was a policy of industrial policy of Assam. And in that industrial policy of Assam, for units which have been already existing, so there are a provision of substantial expansion modernization and diversification. Two things were there. If an existing unit is there, if they invest certain money anew in that particular unit, 25% of the total capital investment, so they get some subsidies. The 2003 policy was very clear about this, that these three aspects, lordship, that substantial expansion, diversification, and modernization. These three contexts, in these three contexts, they can apply for some this subsidy. This 2003 is very clear, lordship. Now, lordship, what has happened is in 2008 policy was brought in. 2008 policy was brought in, and in 2008 policy, lordship, what has happened? It has come into effect from 1/10/2008, and it was up to 30/9/2013. So in that policy, lordship, what has happened? So there was slight change in that from 2003 to 2008. So 2008, what they have done is that the only thing they have kept out of this tree is the substantial expansion. They have removed modernization and diversification.
Removed?
Modernization and diversification. So these are the definitions under which they'll have to claim. So substantial only they have kept substantial expansion. Lordship will find at page 81 of the petition. So substantial expansion has been defined. Now the question has been arisen from under this policy. Lordship, what has happened? One operational set of operational guidelines have been issued by the government of Assam. And in that operational guidelines, Lordship, that is at page 104. What has happened is that substantial expansion, capacity enhancement, and product diversification and process modernization. What has happened is that under the definition of substantial expansion, they have brought in capacity enhancement and product diversification and process modernization. These three aspects also. Now, the case of the petitioner is that since operational guideline has brought in these three aspects, so he is eligible for eligibility certificate under process modernization. The department responded to it saying that since the policy doesn't say about process modernization, it only says about substantial expansion, it cannot be granted.
Tax department. Not industry.
So that is the ultimately also what has boiled down is that there were some communications, interdepartmental communications, because eligibility certificate ultimately has to be issued by a committee. Committee is set up for AIDC committee. The committee, let's say, that is detailed in the policy as well as in the operational guidelines. So there will be one committee which will decide whether eligibility certificate could be given or not. Now, there were some, because in the operational guidelines, Lordship, I'll take your Lordships to that, because this is basically a tax remission scheme under which they have asked for this benefit. Now, under the tax remission scheme also, the tax scheme also, this modernization is not there, because as per the policy, tax department, finance taxation department has come out with a scheme. In that scheme also, this modernization is not there, only the substantial expansion is there. So there was as per the guidelines, that before giving this eligibility certificate, there has to be approval from the taxation department. That is there also.
So for if I remember correctly, as per in the policy,
Lordship,
it was mentioned that operational guidelines should be issued in due course.
Of course, Lordship,
Right?
Lordship.
So as soon as these operational guidelines are issued,
Correct.
it becomes a part of the policy
It's because Lordship,
to work out the policy.
correct, Lordship,
The
absolutely.
operation guidelines are
Has been issued.
treated as part and parcel of the policy.
Lordship, I slightly differ from that because it is, this policy is a policy decision taken by the cabinet. These operational guidelines have been issued by the department, Justice Department. See, it's kind of an executive order, it's kind of a memorandum. So that has been issued by the department. But that has to be issued in consonance and as per the policy. Now, Lordship, the object of the policy is written there, Lordship. I'll just take your Lordship to the object of operational guidelines list. That Lordship will find at page 105.
No, where is the clause regarding operational guidelines
Operational guidelines,
in the
Lordship.
policy?
Lordship, Lordship.
Bill 101, 2014.
101.
Yes. 12.6.
As per the policy, a set of guidelines will be issued,
Set of guidelines
including application forms and procedures.
for
It
getting
is
various
like a
incentives.
statute and the rules. It is like akin to situation is akin to a statute and the rules framed. Statute is passed by the legislature and rules are framed by the government, like
Excellent.
in exercise of the proviso to Article 309, like that. So it becomes a part of the part and parcel.
In that sense, yes, Lordship.
Ah,
Yes, yes.
Then this and both are to be treated as by the government.
It was approved by law,
No, it was approved by, it was approved by the,
government,
It was approved by
by the government.
it is approved by the government.
government.
Yes, that is there.
So-
that is-
This plus the policy plus guidelines. Now cases to be considered within the four corners of the policy and the guidelines.
Yes, Lordship, only thing is that whether the guidelines can bring in new thing, introduce certain thing in the policy. Because policy has been, approved by the cabinet, and this has been done by the executive decision.
The baby is yours.
Yes, Lordship.
In certain situation, petitioner comes before the court saying that the baby has grown bigger than the father. Right?
So that has happened here probably.
No, it is the case of the outsider. For an insider, baby is baby. You are the insider.
No, this is my baby, of course, Lordship. This is my baby, and we have
And
brought him to the earth. That is
one
perfectly
law-
fine.
another law is that all in the government has to speak in the same voice.
I'll come to that, Lordship. I'll come to that.
At 12.4 also you lost me, 12.4.
I'll come to that, Lordship. 12.4 says about the industries department will be if there is some contradictions, if there are some issues, there is some ambiguities, then the industries department will be the ultimate department. We will have the say. Now, Lordship, as far as the guidelines are concerned, Lordship, these are basically operational guidelines for industrial policy of Assam. So the object of these guidelines have been stated, Lordship. Why these guidelines have been brought in? So that has to be looked into, Lordship. Lordship, may kindly have a look at page 105, Lordship.
Yes.
Page 105, introduction. These guidelines have been framed under the provisions of 12.6 of Industrial Policy Assam 208 with the objective to specifying the procedures to be observed for obtaining eligibility certificate, for availing incentives provided for in the Industrial and Investment Policy of Assam 2008, and thus achieving the aims and objectives enunciated in the policy. Period of validity so and so. So this is the object, Lordship. Now the controversy happened, Lordship, why is that this definition, Lordship, this definition has been changed. The definition of substantial expansion has been changed. what they have done, they have introduced capacity enhancement, product diversification, and process modernization in the definition of substantial expansion, which was not there in the policy. In addition to that, Lordship, it goes against the scheme that has been brought in by the taxation department. In taxation department, Lordship, they have brought out this notification that is there at page 196. This is called Assam Industries
Where are the definitions in the policy?
definition.
In the policy?
Yes, Lordship, I'll just. Is at
181.
page 81, Lordship. Substantial expansion, Lordship will find under definitions clause at 3.
Why it has to be considered vis-a-vis page 106, right?
Yes. Page 106.
Now, why it has gone beyond?
Because
106 has gone beyond
because Lord,
81?
because in substantial expansion clause in policy, these two aspects of product diversification and process modernization was not included in the policy. In page 81, Lords.
That is your stand in the affidavit.
Yes, it is my.
Where is that?
Lordship will find my affidavit. Lordship may kindly take up my affidavit.
Operational guidelines. Have gone beyond. Where is the approval page? Approval. Approval to the guidelines.
No, I'm just giving you.
That is there at page. Page 171. Lords.
One second. So your submission is that operation guidelines have gone beyond the purview of the policy.
Yes, that is the precise.
Okay, where is that environment?
Lordship will find at page 8, paragraph 9.
Page 8. 8, paragraph 9 of your affidavit.
My affidavit. Yes.
Page. Two 60. Paragraph.
Paragraph 9, Lordship. The Lordship got it?
Yes.
May I read out, Lordship?
Yes.
That with regard to the statements made in paragraph 6 of the petition, the answering department states that term modernization was not included in the definition of substantial expansion in the policy 2008. In this connection, it is stated that Industries and Commerce Department, Government of Assam approved the draft operational guidelines under the Industrial and Investment Policy 2008. The operational guidelines for the Industrial and Investment Policy of Assam was framed with the objective of specifying the procedures to be observed for obtaining eligibility certificate, for availing the incentives provided for in the policy, and for achieving the aims and objectives enunciated in the aforesaid policy 2008. It is further stated that the aforesaid guidelines provided definition of substantial expansion by including expansion undertaken by the existing units by way of increase in existing installed capacity, that is capacity enhancement, by way of introducing new or improved technology, that is process modernization, by way of introducing new products, services, that is product diversification. It is stated that though the term process modernization was included in the definition of substantial expansion, the term did not provide the basic criteria required for substantial expansion, that is increase of employment by at least 10% at least 25% increase in the production compared to the average annual production of previous 3 years and for 3 years and prior to going for expansion, and the unit should be operating at least at a minimum of 80% of capacity during the period of 3 previous years. In this regard, it would be meaningful to extract the definition of process modernization as provided in the aforesaid guidelines 2008 herein below. The process modernization process modernization will be constituted by separately identifiable investment made by an existing unit or a new unit in the fixed assets involving new improved technology having definite advantages in reduction of cost production service rendered, provided that the additional investment in fixed assets is not less than 25% of the gross value of existing fixed assets. In view of the above, it could be clearly discernible that a process modernization to be eligible for claiming incentive under the 2008 can happen only when the four described criteria definition substantial, namely the increase of employment by at least 10% or at least 25% increase in the product compared to the average annual production of previous 3 years. And prior to going to the expansion, the unit should be operating at, so that's that definition part only that is being given. So we have taken a stand, Joseph, stating that process modernization was not under the policy. Then para 12 also can have a look.
Why, what is the logic? Page 81,
Yes, Lordship.
substantial expansion means,
Yes,
right?
yes,
Now, page 106,
yes,
substantial expansion means and includes expansion undertaken by the existing industry, one, by way of increasing existing installed capacity, within bracket, that is capital investment, comma. Next, by way of introducing or new improved technology, that is process modernization. And comma, 3, by way of introducing new product services, that is product diversification. So substantial expansion means and includes
yes, capacity enhancement
product diversification
and process
and
modernization.
process modernization. Now
Correct.
come to page 81 again.
Yes, Lordship.
Why you are saying that these 4 criteria are not included in
No,
substantial?
Lordship, here, Lordship, then if your Lordship comes to page 106. Under substantial expansion, they have given capacity enhancement, product diversification, and product modernization. 3 aspects. Lordship.
Hmm.
So capacity enhancement, Lordship, these 4 criteria has been given. But for product diversification and product process modernization, those were not there.
But if you go to the definition at page 81,
Yes, Lordship.
substantial expansion
Yes,
equals meeting these criteria.
that is correct. But Lordship, here they have brought in 3 new aspects. One is capacity enhancement separately. One they have brought in product diversification, and one they have brought in product modernization. So these 3 and these aspects of Lordship, 80% capacity and last 3 years criteria and all, those things have been mentioned only in under the capacity enhancement.
When it was published, guidelines,
Guidelines, Lordship. 2010 Lords. It is at page 171, 25th January 2010, it was approved. So basically, let's say what I was submitting is that this three aspects, product diversification and product modernization, they have different connotations. Because investments are different.
My lord, in fact, the same arguments were advanced before the dishonorable court. I've given a judgment. And the same were rejected by my learned friend in respect of the same guidelines. In respect of the same guidelines, similar arguments were advanced. And I gave a copy of the judgment of dishonorable court.
This
Where-
one,
No, my lord, subject to judgment I've given. This is Ladi Steel Industries.
So that's different, Lordship.
No, the same arguments were advanced,
So
my lord,
that's,
and it was rejected.
I'll come to that, Lordship. I'll come.
Yes, yes, I'm just pointing out the same arguments were advanced. That the
Nadi,
operation
Nadi,
Ladi.
Ladi.
I was-
Ladi.
See, WPC 4643 of 2014. There also it was argued, my lord, that the operation guidelines goes beyond the policy.
Ladi. I'm just finding out whether it is available.
Yes.
Available.
Yes, yes, I'm just pointing out, my lord.
Huh.
I'm not disturbing, but only pointing out, my lord, that these arguments were advanced and you'll also look into it. my lord.
So Lordship, in the Ladi Steel, the issue was little bit different, Lordship. I'll just bring it. I'll take your Lordship to that. Because their Lordship eligibility certificate was already granted.
Okay, no, from the affidavit, you want to point out something more?
Lordship, that paragraph 12, Lordship.
12.
That this has been explained again. Paragraph 12 here, Lordship. May I read out, Lordship? That
Hmm.
with regard to the statements made in paragraph 11 of the writ petition, the answering deponent states that in exercise of powers conferred by subsection 1 of section 54 of Assam Value Added Tax Act 2003 and subsection 5 of section 8 of the Central Sales Tax Act so, the governor of Assam was pleased to notify Assam Industries Tax Exemption Scheme 2009 via a Assam Gazette notification dated 3/11/2009. The aforesaid aforesaid Assam Industries Tax Exemption Scheme was made effective from 1/10/2008. It is stated that that date may be Lordship make note down 1/10/2008. It is stated that the Assam Industries Tax Exemption Scheme 2009 was to apply to the units which manufacture goods in Assam, which are considered eligible for partial tax exemption with reference to the industrial and investment policy of Assam 2008. It is stated that clause 2 definition of eligibility provides that eligible units for the purpose of aforesaid purpose of aforesaid Assam Industries Tax Exemption Scheme 2009, wherein category A provides for new units, category B provides for existing units, category C provides for an existing unit which has been declared sick by BIFR or as a government of some government relief undertaking. In the context of the issue on hand, it may be relevant to extract the herein below the relevant category B. Category B, an existing unit which manufactures good in Assam, which undertakes substantial expansion and such substantial expansion is completed and commercial production after such substantial expansion commences on or after 1st October 2008 up to 30th September 2013 and is in compliance with the eligibility criteria under this scheme shall be treated as an eligible unit under category B. Now, substantial expansion has been also defined there. Substantial expansion means increase in the value of fixed capital investment in plant and machinery of an existing unit by at least 25%, as well as increase of employment at least 10% and at least 25% increase in production compared to average annual production of previous 3 years. Prior to going for expansion, the unit should be operating at least a minimum of 80% capacity during the period of 3 previous years and prior intimation to the implementing agency. So here also this substantial expansion has been defined, but there is no mention of modernization or capacity enhancement or diversification.
Did you withdraw these guidelines or definitions?
No, we haven't.
Huh?
No, we haven't.
At any point of time
No, we haven't.
during the operation
No.
since 2010?
No, so we haven't. We have not done so.
That has been admitted in their judgment also, not withdrawn.
Now, also under this policy, for this tax benefits, there is a different chapter. Chapter 7 at page 87. Your Lordship. So page 88, Your Lordship.
Hmm.
So under this policy itself, Lordship, as far as tax incentives are concerned, the finance department has been empowered to bring in a scheme and with that, like whatever the benefits they get. So Lordship, page 88, Lordship will find under 7.1 VAT exemption, there Lordship will find the limits have been given. Then in that same clause, Lordship, at the bottom line, Lordship, if your Lordship finds that Finance Department of Government of Assam shall be the implementing agency for tax incentives. So Finance Department will bring out a separate notification in this regard. So that separate notification is the Lordship, the tax remission scheme.
Once again, where is the approval to the operational guidelines page?
Page 171, Lordship. 171.
Now, once an operation guideline has been issued and a definition of substantial expansion and which is an inclusive definition. Inclusive definition. Now, means and includes. This has some bearing. Means and
And
includes.
includes.
And you categorize three. Then whether by an affidavit, stand taken in the affidavit can be said that this is what we intend. Going beyond the definition, inclusive definition provided in 106. Whether if that is permissible, that a stand, by taking a stand in an affidavit, this is approved by definitely after consultation, operational guidelines. Now, the affidavit, the stand has been taken by a secretary or additional secretary, whatever it may be, that this is not what we intend. This is actually the intention. But after providing an inclusive definition in the operational guidelines, which one will prevail? Which one will prevail? The operational guidelines in the public domain or a stand taken somewhat on a different tangent in an affidavit? Because this is inclusive. It is inclusive means maybe that substantial definition in the policy
Doesn't include
is,
this.
is operational. It cannot go beyond. Those criteria might be included.
No, Lordship, this, as far as operational guidelines, the definitions are concerned. Lordship, our stand is that, yes, Lordship, that is true, that government has issued operational guidelines. But it has gone against the policy, the definition which has been given. That now
But that
when
was not withdrawn at any point of time.
that could not be withdrawn because the litigation has already come up. Already the matter was before this honorable court. Now, Lordship, what has happened is that we have realized that, and it was obviously, Lordship, it was pointed out by the taxation department. Taxation department has stated very specifically that we have framed a scheme under the policy. And as part of policy, this definition is not there. So now how can we give it under the operational guidelines?
Now, where is your final call? Industries department.
Now, Lordship, as far as Lordship financial
No, where is your final call?
No, that's what I'm coming, Lordship. Whether industries department needs to take any call or not, first of all. Whether the time has arrived that industries department should take a call. Because, Lordship, why I'm saying so, Lordship? Because this was application is for eligibility certificate. The application was before the AIDC committee, which has been formed specifically under the policy. They are the authority which will decide whether the eligibility certificate could be given or not. Now, while this thing was discussed, application was discussed, Lordship, then this issue came up whether the modernization, when a unit applies under the modernization, it could be given or not. Then there were several communications happened, Your Lordship, with the taxation department and the industries department and AIDC. Now, as per the operational guidelines, because as per the policy also, the implementing agency is the finance and taxation department. So approval from finance and taxation department is mandatory because they are the implementing agency. As per the guidelines also, approval has to be taken from the taxation department. So because of that, industries department has to write to taxation department for their opinion. Because ultimately the AIDC, which has to come to has to decide, AIDC committee has to decide whether eligibility certificate could be given or not.
Come to 205.
Yes, sir. Lordship. This is a letter written to the principal secretary by the AIDC. Yes, sir. So some clarification has been sought.
No, 206.
Yes, Lordship.
Under the circumstances, the government of Assam in the Industries and Commerce Department is requested to give a decision in the cases of existing unit undertaking modernization in the light of clause 12.4 of the Industrial Policy of Assam 2008 that speaks as the decision of the Industries and Commerce Department, Government of Assam as regards interpretation under this policy shall be final binding. The time has come.
No, Lordship, this is AIDC has written to the Industries Department. So Industries Department has written to the Taxation Department again.
Right, two conflicting views or whatever, somehow AIDC
Now, Lordship,
received the comments from the Finance Department. Then thereafter, he is also part of the implementation process. So he wrote to the Industries Department. This is the situation. Please take a call in view of 12.4. So then when it was, I think 2013,
2013.
then thereafter any response was
Lordship, this petition was filed in 2014.
14.
And Lordship, as far this letter is concerned, to this particular letter, I could not find any response, Lordship, to be fair with you, Lordship. But as I have shown, Lordship, that letter from the Taxation Department. So, Lordship, what my contention is that, Lordship, because department is not speaking in two voices here. The department is speaking in all the departments, the Industries Department also, they have taken a concerted view that it cannot be given. They have taken the opinion from the Taxation Department, and that has not been disputed by the Industries Department. They have not stated that this is not correct. When the two departments will speak in two voices, when the two departments are speaking contradictory. Here, what Taxation Department is saying, I am also saying the same thing. I have not disputed. When I have
So Industry Department is not required to give because it will sail with the view of the Finance Department. That is your submission.
no, what I am saying is, Lordship, by this letter, that Lordship is there, Lordship is already.
No, so in us, otherwise, since we are taking both the repetition together, in the other one, you have sailed, you have quoted, extracted the Finance Department view,
Right, Lordship.
right?
And I haven't disputed that.
All right. So in the other one, Finance Department has expressed its views. You have quoted first to last sign.
Yes,
So
Lordship.
that is the position,
Yes, Lordship.
right? In the second repetition.
Correct, Lordship.
Here, when AIDC Managing Director was asking for your views by this letter, according to you, the Finance Department, that is, they have said somewhere that expressing their view that substantial expansion,
Yes, that is there in the letter,
Ah.
Lordship.
that
The other
page
letter.
195,
Page 190.
190.
Yes, Lordship. Page 190 of the second petition.
No, first I'm taking up first.
First petition, Lordship.
I think 195,
195, my lord.
195.
My lord.
195, Lordship.
So you go by the Finance Department view. You are sailing with Finance Department view.
Lordship, that there was another letter of 2016 of the Finance Department that is page 190 in the second petition.
That is
It-
quote
it-
unquote,
It's almost same.
quote unquote.
Almost same.
Ah.
The same view, Lord. So
That-
same book.
No, here it is 195.
There, Lordship.
It is written to Managing Director AIDC.
Correct.
Then since AIDC is not subservient to Commissioner of Taxes. He decided to ask for an opinion from the industry department.
Because all the stakeholders are there.
Stakeholders, but
Correct.
not subservient.
Correct.
He is one of the part of the decision-making
Absolutely.
authority. He is not subservient. So he responded that Commissioner of Taxes is writing like this. So please, Principal Secretary, Industry, please give your final view. That is 205 letter. So on this, you have not responded.
Yes, Lordship.
But basically, you like to say that we are sailing with page 195. This is your submission.
Because all the decision has been taken, Lordship. At that point of time, as far as this letter is concerned, 195 was written prior to that.
Yes.
Correct.
Yes.
Then
Subsequent to that,
subsequent to that, we could not reply to that, respond to that. Then this writ petition was filed.
writ petition, it took about 1 year.
Lordship,
after-
that's
was-
correct,
That
that's
was on 4th January 2013.
Correct, Lordship.
AIDC wrote to you. And this was in 28 May 2014. 1 year, 3 months.
That was sometime.
3 months.
Correct.
So till that time, you have not taken any decision.
We have not taken, but like second writ petition when it was filed, so the another letter was written to us, then we responded to the letter.
Page?
Page 189. So here, Lordship has to read this letter along with the other two letters. The first Lordship, may I take your Lordship to the letter number, page 186. This has been written by AIDC to the Industries and Commerce Department. But it was because that other case,
The crucible.
other day, Lordship, we were reading about those letters that regarding that manufacturer and all these things. So those have been quoted by them. If your Lordship recollects that because 57A was there, then that was struck down. So that issue was there before this honorable court. Then they have written this letter, AIDC. Because since that has been struck down, the judgment has been passed. So what is to be done? So this
But yes, the most important letter is at page 189 perhaps.
yes, 189 also. 189. That 189 and 190 also, Lordship. 190 has been referred also.
Oh, that is Commissioner of Tax.
Yes. So
Now
so
this is
Lordship,
your letter, 189.
correct. So after
So where is your view?
so views of the finance department hasn't been disputed by me, Lordship. So this is
It
my
reminds me of slightly of Uttapur.
Lordship, this is a
It
concerted,
reminds me of something
concerted,
like Uttapur.
concerted opinion, Lordship. It's a stakeholder is giving, who is the implementing agency. So I need not say anything more than that. That's what the.
Something
view
has
for-
gone beyond Uttapur in the meantime.
So
But
Lordship,
ahead. That is all.
one or two more things, Lordship, because I'll just wind up shortly. Lordship.
No, if something, then I have to write some meeting is there.
Lordship?
Some meeting is there.
Then Lordship, I'll have to differentiate these
Mr.
case laws that.
Gogoi, you have to say
Gogoi has to
something. You want something to say, submit?
Yeah.
Yes,
Then-
I also point out a couple of things.
then
And then
Mr.
the cases has to be
It will not be,
distinguished.
Mr. Sarah, will not be possible today to end.
My lord, your lordship may give them time. Your lordship, just for my satisfaction, the judgment of this on the court. no? Only for, my lord, they can argue, there is no problem.
That something, what is?
Then Ladi still.
Ladi.
My lord.
Ladi to light house na that. I do see about to Ladi to silent bar. Yes.
Lord, I'm just two paragraph, para 17, my lord,
Ladi.
para 17. I will take 2 minutes only.
Hmm.
Per contrast, Sri Kalita, the learned standing counsel for the department has submitted that the first eligibility certificate was issued on so and so. The objective of policy was not looked into minutely, and by error, the unit has held to be entitled to incentives on the electrical installation other than the developed power line. By referring to the definition of fixed investment, he submits that the installation would not come within the definition, and therefore the policy would not allow the unit to give in the incentive above. He clarifies, so far as the power line is concerned, the unit has already availed the incentives which has been quantified so and so. With regard to the minutes of the meeting, the learned constituting was submitted. It is the policy which is the substantive law, and guidelines which have been notified in terms of the policy cannot supersede the substantive law. He further adds that even if the guidelines may take the color of the legislation, the guidelines cannot be taken into consideration for matters which are directly in conflict with the policy. He submits that the policy does not provide for such incentives, by the guidelines providing for such incentives is not permissible. Exactly, my lord, the same arguments. You will also kindly thereafter see para 26, my lord. Para 26. The court finds force in the submission of learned senior counsel for the petitioners that the first eligible certificate so and so was after the minutes of the meeting held on so and so. Whether a state level committee would have a jurisdiction competence to question the operational guidelines framed under the policy itself is a debatable issue. In any case, the operative part of the observation is the recommendation to rectify the operational guidelines by issuance of necessary corrigendum. There is no manner of doubt on the part of the court that the state level committee will not have the competence to declare the operational guidelines as invalid. It would be a different matter if such guidelines were rectified by the competent authority, in which in this case was not done at the relevant point of time. In the last one paragraph, para 31. Para 31. In the instant case, this court has noticed that it is the case of the parties that the operational guidelines was the subject matter, not the subject matter of challenge. This court is of the view that the guidelines which were framed under Chapter 12 was only to supplement the policy and make it workable. Until such guidelines were existing, it was the obligation of the authorities to follow the same.
Your Lordship, only one
No,
difference.
I'm not.
I'll place it, Lordship.
Okay, okay.
No, he can argue, my lord, I just.
Yeah, yes,
Okay, yes.
Only thing is that, Lordship, their eligible certificate is already granted, and it was
That not,
They
not
wanted
on
to
the
take it
facts,
away.
not on the facts, I am on the ratio of the decision law.
Okay.
My lord, if you showed something adjustment, if your lordship can do, because the lordship is sitting, I understand, the lordship is sitting in the division
Sitting
bench.
in a division bench,
And it is-
that has to be given
My
precedence.
lord, you know, actually, my lord, I will never,
Persons are behind bars.
well, I can never say, my lord, that. your lordship-
That 7 years, 8 years.
But my lord, if you're Tuesday for, I think 45 minutes will be sufficient, Mr. Kalta. If 45 minutes are there, my lord, then,
We have also fixed other matters there,
my lord, I think.
criminal appeals.
3:30, my lord, instead of 3 o'clock, 3:30, my lord.
Because we have fixed for disposal only. Oh, it will cater if I say. 10, 11, 12 is not possible. 13 can be possible.
3:30.
13. 13, huh?
And all endeavors should be made by.
Yes, right.
By
13.
us, my lord, that to finish the arguments.
If the division means we can rise, then we'll immediately take up.
My lord.
Heard.
I'll not take much time, Lordship. Only the case laws and other.
Mr. Kalita always says, my lord, he will not take much time, but thereafter,
Yes,
I don't think.
Agorkini Lihido are present. Mr. Kolita has submitted that he would continue his submission on 13/6/2024.
my lord, only I would like to know one thing, my lord. That Mr. Kalita is appearing on behalf of the industry department, which is there, which is notification, or is appearing on behalf of the government of Assam. He cannot appear for both now. Because either he has to appear for the Director of Industries or for the government of Assam. He cannot appear for both. Because here the difficulty is there. operational guidelines, he's arguing that it is contrary to this. So whether he's arguing on whose behalf? One side, this side, he cannot argue for both.
Now I'm going to repeat for you. Continue his submission, 13.6. Lays the case accordingly on 13.6.
His position is not very difficult because
Yes,
first argument he made for 15 minutes on behalf of the industry department. Then he jumped to the government of Assam. How it can be made up?
He jumps to Commissioner